Okay, so civil procedure. What is civil procedure? So you know civil procedure is a mandatory course, and it's more specifically about the rules and principles that are used in our legal system to resolve non-criminal disputes. So I'll just kind of unpack that. So we're talking about rules, right? People think of civil procedure as a black letter law course, and they're not entirely wrong. We have the Ontario Rules of Civil Procedure, which is kind of the core legal text for this course. There are regulation under the Courts of Justice Act, and the body of case law, of course, which interprets the rules of civil procedure, is also part of that rules core of the case. So the rules of civil procedure are lots of fun. We're going to have a great time with them. But my view is that if this course were just about the rules of civil procedure, it would be inadequate. Because for several reasons. First of all, like all regulations and legal rules, they change over time. They'll be quite different in 20 years. Also, they don't apply to every dispute, right? Many of you will leave the province of Ontario, practice elsewhere. Many of you will practice in administrative tribunals or in family court or in some other type of civil jurisdiction, civil practice area, which is not in fact bound by the rules of civil procedure. Right? The rules of civil procedure are kind of the core that we use for all civil disputes which have not been assigned to a different venue, but many types of dispute have been assigned to a different venue. So this course is supposed to introduce you to the principles, which is to say the broader ideas which you will find at work no matter what type of civil litigation you end up involved with, anywhere in the common law world. Okay, so what are examples of some of these principles? Audi alterum partem, hear both sides. So this is something which is so elementary that it scarcely bears emphasis, but the idea here is that if you're going to make a fair decision, if you have a judicial process, that judicial process should give all sides, or both sides, the chance to be heard. We can't do justice, we can't find the truth, we can't move the law forward unless all parties who are interested in a dispute have a chance to have their say. Another big principle we'll come to again and again is proportionality. What is proportionality? It's a big fancy word for an idea which is actually pretty commonsensical. Proportionality is the notion that we should not allow the expense and the inconvenience of civil procedure to become disproportionate to what it is people are arguing about, right? So our pursuit of procedural justice and our effort to hear both sides can, if unchecked, lead to a procedure which is grossly disproportionate to what people are arguing over. It is depressingly common for people in the Ontario civil justice system to spend $100,000 arguing over $50,000, right? And that's kind of the nightmare of the system, that we'll go so far down the road of trying to be fair to people that we end up with a completely disproportionate procedure. So this is something which has come more and more into our law from the Supreme Court on down, the directive to be proportionate and to make decisions about civil procedure with an eye to avoiding disproportionality. So for example, we'll get to Rule 20, right? So Rule 20, the summary judgment rule, this is like the black pit of despair and complexity of civil litigation. It's a very complicated rule. We're gonna have a lot of fun with it. And it's designed to bring a form of proportionality to civil procedure. Rule 20, and you don't need to know Rule 20 right now, I'm just using it to illustrate the idea. It's one of the things that the rules have created to try to make procedure more proportionate by letting slam dunk cases get to a quick adjudication and skip some of the steps of civil procedure that other cases have to go through. Another big principle to put on the table right at the beginning is party control. So this means that the litigants themselves are, to a very significant extent, in control of their civil litigation. So, if you are a defendant in a criminal matter, you are not in control of criminal process, right? Criminal procedure, it's basically the crown, which sort of moves you through stages, and you have a chance to defend yourself and so on. By contrast, in civil litigation, what happens is very much in the control of the parties and not in the control of the judge or the control of the system. So an example of party control, we're going to talk about pleadings, right? That's our first topic. Pleadings, this sort of conversation and documents that you use to begin the case. There's deadlines for pleadings, right? In principle, the defendant is supposed to file their statement of defense 10 or 20 days after the statement of claim goes in. But if the plaintiff agrees to let the defendant take 5 months to submit their statement of defense, that's fine, right? The system lets the parties themselves control it. And if you can have a piece of civil litigation, there's certain cases which have been on the books in Ontario for 5, 8, 10 years, simply because neither of the parties have found it in their interest to push the matter along. So party control is another principle. Now you can probably already see that these principles come into conflict with each other, and there's various other principles we'll put on the table as well. But some of the interesting tensions and controversies in civil procedure come when these big important principles, which we all want to uphold simultaneously, cannot be held equally powerful without some type of compromise. Okay, so the rules, the principles, and the practices by which civil disputes are resolved according to the law. So this is meant to be a practical course, right? Many of you will, at some point in your careers, and perhaps as a full-time legal practice, engage in civil litigation. This course is meant to show you the strategies and the ways of thinking which will let you advance the interests of your client through the civil litigation system. We're going to try to talk as much as possible about what strategic considerations, what financial considerations are going through the heads of parties when they decide to bring this or that motion or decide to take a particular strategy with regard to evidence. Because this is not just like a set of interesting principles and rules. This is supposed to be a toolbox that you can take to have great success as a practicing lawyer and advance the interests of your clients. Okay, so we're going to look at all that, but with regard to disputes, but not just any disputes, civil disputes. This course is meant, as I said, to be as broad and useful a preparation as possible for as many different types of practice that you might engage in as possible. So we're thinking of civil disputes as all non-criminal disputes. You have a course in administrative law, so we're not going to tread on that too much, but we are going to look at these principles and practices as broadly as possible with a view to seeing how they work in all sorts of different non-criminal contexts, including family court, small claims court, class action practice, and a little bit of administrative stuff on the edges. Okay, so civil disputes, this is a huge category, right? So a civil dispute includes everything from the most picayune minor squabble between neighbors over the backyard fence boundary, right, which they foolishly choose to elevate into litigation, all the way up to Samsung versus Apple, right? Hundreds of billions of dollars of intellectual property dispute going on to 10 to 15 years. And civil disputes also extend into many things that we think of as social justice questions, right? Particularly towards the end of the course, we're going to be talking about constitutional law, public interest litigation, and ways to use the civil litigation process to not only advance and protect private interests, but actually make the law better, and even hopefully make the world a better place. Okay, so all of that according to the law. So obviously this includes standard black letter law, reported decisions. We're going to read lots of cases arising from motions and different trial procedure questions. But according to the law, also includes alternative dispute resolution, negotiated and mediated settlement, right? So according to the law, in the sense of in the shadow of the law, because when people use mediation or they reach a negotiated outcome with reference to legal norms, they too are resolving their civil dispute according to the law. So ADR is absolutely core to civil procedure, both because it's the primary method by which good civil litigators protect the interests of their clients, and also because ADR, and when I say ADR, I mean negotiated settlement, mediation, and arbitration. ADR and adjudication are constantly in conversation with each other, right? The negotiated alternative dispute resolution that people reach is informed by what they expect a court might do if they don't settle. And likewise, many parts of the rules and many of the things that we'll see judges doing in these reported decisions only make sense when you realize that the system is trying to produce settlement at the same time that it's trying to produce justice. And those are odd bedfellows, but they have to be in that bed together. So hopefully the practice simulation you guys all went through last year has already maybe given you a bit of a sense of how lawyers pursue settlement in the shadow of the law. Okay, so turning back to the syllabus, if you go to the bottom of page 1, you will see the goals of the course. So first of all, learn the main steps through which civil litigation proceeds. Over the first half of the course, next 6 or 7 weeks, we're going to follow a conventional civil action from beginning to end. We're going to look at a specific case that I'll talk to you about later, and we'll look at all the rules that were applied to it. Secondly, become acquainted with the rules of civil procedure and other key procedural statutes. So I talked about the rules of civil procedure. There's a few other very important ones. The Courts of Justice Act is the statute under which the rules are a regulation. Some of the key entitlements and principles are found in that Courts of Justice Act. Acquire familiarity with the terminology of civil procedure. One of the challenges of CivPro is that it tends to generate a lot of lingo, a lot of weird words, and even more confusingly, a lot of like normal English words that the civil justice system kind of sucks out of context, and it gives them a completely different meaning that you would never anticipate. So we're going to try to get a handle on the lingo. There's footnotes in the text that I put there to try to explain some of the more counterintuitive terms. Seeing how lawyers advance their client's interest by using civil procedure, how lawyers seek to access justice through civil procedure. Because civil procedure ultimately is supposed to be a way to create access to justice for clients. And that's the only point in having all this, is that it's supposed to be a set of mechanisms which give clients access to justice. Now, the civil procedure system is also, many people would say, a disaster from an A2J point of view. And we're going to look at why and how that might be. We're going to look at some of the more creative mechanisms that we've tried to come up with to make the civil justice system an actual route to access justice, as opposed to a place where access to justice goes to die. And we're going to try to think critically about the extent to which these rules and practices we've adopted for civil procedure are working to create access to justice. Okay, finally, observing how and why judges and legislators make changes to civil procedure. As you know by now, law is a constantly changing kaleidoscope of interests and sort of rationales and rules changing for different reasons. We're going to try to get a sense of why the rules have changed the way they do, how they might change in the future. And of course, once you're called to the bar, you will collectively have responsibility for improving this. right? We have a civil justice system which is very much controlled by the lawyers and the judges who practice within it. Even though the rules of civil procedure are a regulation of a statute and they could be changed by the legislature at any time, the reality is the legislature does not touch the rules of civil procedure. Politicians, right up to and including the Minister, the Attorney General, generally see the whole thing as like a complicated, sort of confusing morass that the legislature does not want to wade into and make changes. So changes de facto come from either precedent, the normal process of common law changing things, or they come from these rules committees, which are basically lawyers and judges getting together and fiddling at the edges and changing things and trying to make them better. You will all be part of that process, and hopefully you'll enter upon it with a sense of the potential to make things better. Okay, so the course has two parts. As I said, part one is about the conventional civil action, right? So the plain vanilla, most traditional civil lawsuit from beginning to end. A conventional civil action can happen when certain precise conditions are met. First of all, you have to have a small number of parties who are involved. They have to be litigating about their own civil rights in the same province, litigating in the same province, and the process has to culminate in a judicial decision about who's right and who's wrong. So we're going to go through in the first half of the course how that happens, right? The stages that bring us at. So first of all, pleadings, right? Pleadings are it's an exchange of documents by which the parties tell their stories and define the legal dispute between them. Service, amazingly, there's a whole set of rules about how to deliver your documents. That's what service is, right? And we're going to look at that. We won't beat it to death, but it's important to know about. A motion. A motion is a request for a judicial decision, which is not at a trial or an appeal, right? So we'll see that that civil procedure, because of its complexity, often requires judges to make decisions about the procedure itself, right? So that's procedural motions, where you're just trying to get a ruling on what should happen next. You know, does the other side have to answer these questions? Can I serve my document in this way versus that way? So that's procedural motions. We also have substantive motions, which are judicial decisions about substantive legal disputes between the parties that do not follow a trial. So motions will be a big topic. Discovery. So discovery is getting at the facts. Discovery is the process by which litigants serve and deliver to the other parties information which will assist the process in coming to a conclusion. So we have oral discovery where parties question each other. We have documentary discovery where parties have to disclose all documents they have which are relevant to the matter of dispute. And we have some, next topic, privilege. Privilege are exceptions to the general obligation to disclose all relevant information you have about the dispute. Right? So discovery is the principle. Everyone's got to put all their cards on the table so we can get at the truth as completely as possible. Privilege are reasons to say, whoa, maybe there's certain things which should be shielded, which should be protected, which should be held private. And the classic example there would be lawyer-client privilege. So someone's discussions with their own lawyer cannot be compelled through discovery or disclosure. And then there's various other forms of privilege as well. Topic 6, juries and trials, right? So this is the traditional kind of point at which a judge will decide who's right and wrong, apply the law to the facts after finding those facts. We're going to look at the jury system. We have, for a proportion of our civil trials are conducted before juries, the majority are not. And there's lots of things for people to fight about in terms of whether there's going to be a jury or not and what the role of the jury will be. We'll also look at trials themselves. There's another course called Trial Advocacy, which will get into the mechanics and the strategy of actually conducting a trial, but we are going to look at the basic process of that. Enforcement. Litigants are often surprised and not particularly happy to learn that once you have a trial and the judge says you're absolutely right, your adversary is absolutely wrong, that judicial order is not self-enforcing. If you want to actually take those beautiful words on the page of the judgment and turn them into reality, turn them into an actual, money in your bank, or return of whatever it is you say was wrongfully taken from you, you need to engage in enforcement activity, which is kind of like an extra bonus round of civil procedure, where you try to garnish money from the other party's bank account, seize the things that you're owed, and so forth. Finally, cost awards. So lucky you're on this side of the river and not the other side of the river, so you get to learn about Ontario's unique and wonderfully interesting cost system. So this is also known as cost shifting, and the basic idea here is that a party who is successful in civil litigation should be entitled to something extra from the other side, right? Because if you sue someone for $100,000 and the judge says, yes, you absolutely are entitled to $100,000, and they pay it to you, you are still out of pocket, because guess what? You had to spend $30,000 or $40,000 paying your lawyer and conducting the civil litigation just to get to that point. So we have a cost shifting system where there's extra money which goes back and forth between the parties after litigation, and it serves various functions, but that's one of the main ones, is to compensate successful parties for the trouble they had to go to get there. Okay, so this is the conventional civil action. I use this image of this person sitting down this mysterious and kind of dangerous winding road to represent what the conventional civil action feels like to the people who walk this road. From the lawyer's point of view, your role is to help your clients down this winding road with the goal of ultimately reaching that beautiful sun-drenched valley you can see at the top of the picture there, right? And that beautiful sun-drenched valley up in the mountains is adjudication. That's the moment when the system vindicates your client and protects the rights that your client lost, what they lost due to the illegal behavior of some other party. From the judge's point of view, the conventional civil action is also kind of like a long and winding road, because the judge in our system has to stay up there in the mountains, right? Judges are impartial, neutral arbiters in our system. A judge has the responsibility for saying what happened, for finding the facts, for identifying the applicable law, and then applying the law to those facts and making an order which is meant to bring the world into alignment, into better alignment with the law. To do that work, the judge needs to know what happened, they need to know the facts, and they need to know the law. But the thing is, our judges work within an adversarial system and not an inquisitorial system. The judge cannot come down from the dais, go out into the world and investigate and find out what actually happened. They have to be reactive. Therefore, the judge has to depend on the facts and the law that the parties bring forward and present in court. So judges are basically forbidden to come down from the mountain, and the parties have to walk that road so that the judge has the facts and law which he or she needs to do their job. Okay, so that's the idea, and we're gonna look at the road. This conventional civil action is a well-traveled road, right? It's evolved over 5 or 6 centuries. We inherited it from the English, and we've made certain changes to it. A lot of effort has gone into making it fair as possible. But there are 3 big problems. with the conventional civil action. First of all, this road is long. It takes an average of over 2 years to get a civil matter from pleadings to trial. Right? So the average trial, which happens for a civil matter in Ontario, if you go back in time to the file, you see when the statement of claim is filed, it's on average 2 years before. It's a very costly road. That's the other problem, right? The average lawyer's fee for a civil lawsuit culminating in a 5-day trial is $44,000. Right, so that's just one side legal fees to get from the statement of claim up to a 5-day trial. So clearly, we're talking about something which only corporations or the wealthiest people can ever hope to actually walk from the beginning right up to the end. It's also a narrow road. The conventional civil action is a narrow road. Right? As I said, it works when you have a small number of parties who are all within Ontario, and they're all mentally competent adults, or they're all corporations, and they have a private dispute, right? Which is a dispute about typically money or some sort of obligation between them, and not a dispute about with broader social justice ramifications. So the road is long, it's costly, and it's narrow. If this were the only road to justice, then we'd be in big trouble as a society, right? If this was the only way to actually vindicate and uphold civil rights, we'd also be in trouble as lawyers, right? Because it would be almost impossible for us to get good results for our clients, to actually help them out with their civil legal needs if we had to walk this road from beginning to end every time we wanted to do so. So, we have shortcuts on this road. We have halfway houses, and we have other routes which can lead litigants to other types of justice. And that's what part 2 of the course is all about. Other routes to civil justice. Detour. Okay, so the most important of these, okay, so let's start with disposition. Okay, disposition without trial, not the most important of them, but somewhat important. Disposition without trial is a set of procedures we have to end a case completely without having to go all the way to trial. So I mentioned summary judgment before, right? Which is like sort of the mini trial that lets the most slam dunk obvious cases get heard extra quickly and gives a party a complete win without having to go to trial. We're going to look at 7 different disposition without trial techniques. Another one, just to give you a flavor, is based on the Limitations Act, right? So who knows what the Limitations Act is all about? Exactly. Yeah, it's a timer, right? You have to bring a civil action within a certain period. So if you are sued by someone who is suing too late, too much time has gone by since the thing they're complaining about, then you can bring a Limitations Act action, which is a form of disposition without trial, because you can get a complete win without having to go all the way to trial. Okay, then we get into alternative dispute resolution, arbitration, negotiation, and mediation. So arbitration is simply privatized judging. It's where parties submit their dispute to someone who is not a judge, but who has the same authority which a judge would have to impose a resolution on the parties. Negotiation, you all know about from the practice simulation, right? This is where parties, without the aid of a third party, are able to reach a conclusion which they both agree on. And finally, mediation, which is negotiation assisted by a third party who is neutral, but who does not have the authority to impose a resolution on the parties. Okay, class actions. So the class action is designed for civil disputes where a large number of people have suffered a civil injury of some kind, but the wrong is dispersed among so many people that it would be disproportionate for each of them to sue individually. So the class action is a way for a whole bunch of wronged people to get together and pursue that claim together, typically against a single defendant. Disability and guardianship, this is what we do when someone is a minor or when someone is mentally incapable of making decisions for themselves. How does the civil litigation system deal with that? Private international law. So this is about civil disputes which cross borders in some way, right? So someone is injured in a foreign jurisdiction, they want to bring a lawsuit in Ontario, or the injury happened in Ontario, the defendant is abroad. How does the civil litigation system deal with that? And finally, intervention and public interest standing. So this is about cases which, where it's no longer true that we're talking about a small group of people with private interests. So intervention basically means inserting yourself into someone else's lawsuit because you say it affects you as well, the outcome will affect you as well. Public interest standing is where you have no personal interests affected at all, but you are asserting the right to bring that claim on behalf of other people. So this would be often public interest organizations, social justice activists who are bringing a dispute to court which affects other people. And that's one of the ways, that's the primary way by which civil justice can be a tool for advancing social justice. Okay, so that's the outline. Great, thanks very much. I'll see you virtually on Thursday.